You're adding more definition to sole basis to explain it, to say that we would
Right.
not just.
I was trying to provide some comfort that the imposition on for a permit would be.
Jonathan, if I may interrupt. Okay, enough is enough. My 5 minutes is up, Fran. I can start terrorizing people again. You know, I'm all for providing comfort, but there's no way to predict what a future board, what a future regional board, what future general counsel, future deputy directors and executive, officers and directors will do. I mean, it is what it is. There is a process in place that should someone truly abuse the discretion and authority that is provided to them by law, that those things are taken up to the state board for petition. I appreciate LA County's concerns, but I think it's getting to the point of ridiculous now. Therefore, I will make the motion to adopt the amendments with the, were there any change sheets? No change sheets? No change sheets, okay. And retaining the word sole, because I believe that was the intent of the two colleagues to my left who voted for that resolution, and they may correct me. And I would also add this additional resolve, because as Mr. Laufer said, it's just simply restate our understanding and the facts of law with respect to the board's authority to protect these areas. So again, my motion is to adopt the amendment as is, as proposed by staff, with this additional language in the resolution.
And I would just clarify one thing. Your staff tried to do you a favor, and the resolution that's before you includes a link that includes both the amendments on this item and on the next item. So I should be clear that the motion that the board would be considering this time is to adopt the staff recommendation with the attachment, but only those portions of the attachment with the blue underlined text and the blue strikeout text. Those are the only provisions related to the marine protected areas, the state water quality protection areas.
Thank you, Mr. Alfer.
I see you reaching for your microphone, Francis. We'll tell the world.
I'll second the motion.
Any further discussion? All those in favor signify by aye.
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 Opposed? Thank you.
Thank you, Johanna.
It doesn't always work that way, Johanna. Look, things were tense there for a minute, weren't they? We just did that to see if you could perspire. Mr. Howard, number 11, please.
Yes, well, before I introduce number 11, I'd like to thank Joanna Weston, as Tam did. She's a Sea Grant Fellow with us. I understand she's going to be leaving in February, even though we'd be delighted if she elected to stay with us. But just wanted to express our appreciation for her work on this item. And with that,
Good work.
We would concur with that. Hope that you stay, Johanna.
with that, next is item 11. This item is regarding the proposed amendments to the California Ocean Plan addressing model monitoring, vessel discharge, and then non-substantive changes. Presenting this item is Maria de la Paz Carpio Obeso, who will introduce the other staff, since I don't have enough breath to name any more names.
Thank you, Tom. I like my name when he's saying in the perfect way. Thank you very much. I really appreciate it. Well, yes. Mr. Hopkins and honor board members. As Tom just mentioned, We are continue with some amendments in the ocean plan for the 2009 with 3 aspects: the model monitoring, the vessel discharges, and non-substantive changes. I will share some of the public history that we have in the process, and later on I will try to mention the main changes regarding the 3 aspects that I just mentioned. The first draft of Substantive Environmental Document, SED, was released in 2006, and we held 3 public stakeholders meeting, one in Santa Rosa, the other in Los Angeles, and the third in Monterey. We request to the public to give us some feedback about this first draft. Later on June 26, 2007, we hold a public scoping meeting in San Francisco. Once again, we request to have some input on the 3 proposed amendments. On November 1st, 2011, we hold a board hearing here in Sacramento, and once again, we request public participation and give us some comments and feedback about the 3 amendments. On August 22nd, 2012, we have our workshop here in Sacramento, and we present the draft SED. Again, new comments to the public. We received 2 of them, and one of them was in support of these 3 amendments. The draft final SED report was released at the beginning of this month, and now we are here to consider the adoption of the 2009 Ocean Amendment regarding the model monitoring, vessel discharge, and non-substantive changes. If the adoption takes place, our next step will be to have our new ocean plan amendment submitted for approval to the Office of Administrative Law process. Later on, we hope to give to the U.S. Environmental Protection Agency for submission. That is regarding the process. That is the history. We give enough opportunity to the public to give us some feedback about all these 6 years that took to have unto you this draft SED as well of the staff report. First, let's continue talking with monitoring. This morning we talk a lot about monitoring, but this regarding the ocean plan, it was with the driving force of this amendment was to create a consistency in the ocean monitoring. And also it was like a response of the Senate Bill 72 that was signed in 2001 that states that the State Water Resource Control Board shall be trying to develop a minimum requirements for model monitoring. The model monitoring has a question-driven model. It's a framework rather than only gather some data. As I said, the model monitoring will give us the framework, and it has 3 components. One is the core monitoring, the regional monitoring, and spatial studies. Regarding the core monitoring, it is a specific monitoring necessary to measure compliance with individual effluent limits or impacts of receiving water quality. Regarding regional monitoring, it provides information necessary to make assessments over large areas and evaluate cumulative effects of anthropogenic inputs. And the spatial studies provide response to a specific management or research questions identified through either core or regional monitoring. All the receiving waters in ambient water monitoring conducted through the monitoring regional program should be compatible to the surface water ambient monitoring program quality assurance. The water quality data are reported as well in the CEDEN, California Environmental Data Exchange Network. Most of the changes regarding model monitoring take place in the Appendix 3 of the California Ocean Plan. It has 3 different kinds of discharges, such as point sources, the stormwater, and non-point sources. As I mentioned previously, on August 22nd, we have 2 comments, and one of them, we took in consideration the change regarding the bioaccumulation. We remove of monitoring requirements for marine parks and marine conservation areas. This is inconsistent with the State Water Quality Protection Areas Amendment. The other part of these amendments is the Vessel Discharge Amendment. The Vessel Discharge Amendment changed the capability section of the California Ocean Plan in order to make the plan applicable to vessel discharges. This will create consistency between the Ocean Plan and the federal laws and regulations. This will apply to large passenger vessels and ocean-going vessels. The vessel discharge must comply with the State Lands Commission requirements for ballast water discharges to control and prevent the introduction of non-indigenous species. Discharges of sewage and sludge from vessels are prohibited in not discharge zone promulgated by US EPA. We also add some definitions regarding vessel discharges, such as gray water and oily vehicle water. As non-substantive amendments, well, we put update the maps that are in the ocean plan. We rename the tables that was in alphabetic order to numerical order, and we took in consideration some grammatical and editorial modifications. With this, well, I think that we provide enough opportunities to the stakeholders regarding the public meetings, the workshops, to give us their feedback regarding the amendment to the 2009 Ocean Plan regarding model monitoring, vessels, discharges, and non-substantive changes. If you have questions.
If I could add one thing, Dominic asked me to point out that we are adding a number of definitions to the definition section of the Ocean Plan, and wherever those definitions occur in the new language, you'll see there should be an asterisk next to it to aid the reader in figuring out which things are specifically defined within the Ocean Plan. So we would, that doesn't occur in every place that you see those in the current Appendix A, but we would definitely correct that.
Mr. Freeze.
Chair Hoppen, board members, my name is Phil Freeze. I'm the Technical Services Department Head for the Sanitation Districts of Los Angeles County, and I'd like to express the strong support of the sanitation districts for staff's recommendation to adopt amendments including a model monitoring framework with minimum requirements for all ocean monitoring programs. The sanitation districts have conducted our coastal monitoring program under a similar framework, as a requirement of our NPDES discharge permit since 2006. And we believe that the use of this framework has significantly increased the scientific value of our monitoring effort. The framework has substituted modest reductions in repetitive core monitoring with more valuable regional monitoring requirements, including participation in BITE studies, the Santa Monica Bay Comprehensive Monitoring Program, and kelp bed canopy surveys. These regional studies provide an assessment of conditions beyond the immediate vicinity of the wastewater discharge. They examine impacts from all stressors, and they provide context against which the outfall intensive monitoring can be compared. Although they're somewhat different from SQUIRP's original model monitoring program framework that formed the basis for Southern California's coastal monitoring program, the requirements associated with staff's recommended alternative appear reasonable and appropriate as a baseline effort for coastal discharge types and volumes considered. Thank you for the opportunity to express our support for these amendments.
Thank you, Phil. Our sole remaining Sarah. See if you wait, you're number one.
From 3 to 1. Good afternoon, Sarah Sikich with Heal the Bay. We're here generally to support the vessel discharge draft amendments, and we really appreciate the language changes made by staff in response to our comments that amend the plan to state that sewage discharge from vessels is prohibited according to the California Clean Coast Act. We also support the model monitoring program amendments generally. However, we do have some recommendations regarding them. First, the state board should broaden the applicability of these model monitoring requirements to include other types of non-point waste discharge sources besides agriculture and golf courses. Other non-point sources such as grazing can negatively impact water quality, and we don't think they should be excluded from the minimum monitoring requirements. With respect to the bacteria monitoring, we support staff's addition of language to clarify that permitted stormwater discharges and non-point source monitoring should occur at point 0. As you know, this type of monitoring is critical for public health protection. In order for the state board to fully account for public health and beneficial use protections, we urge you to stipulate in the amendments that the additional sampling points should be designated at set distances away from the discharge points to help better understand the fate and transport of pollutants. Also, the amendments should go further to specify that these samples shall be collected at least on a weekly basis, rather than vaguely stating that indicator bacteria monitoring should take place at a minimum of 5 times per month. If that's not explicitly stated, all samples could potentially be collected in the same week. This scenario would not be protective of public health and would not give regulators a complete picture for compliance purposes. The draft amendment specifies that at a minimum, receiving water at outfalls greater than 36 inches in diameter or width must be monitored during 3 storms when flowing during dry weather at AB 411 beaches. Beaches that are defined under AB 411 should be monitored year-round on a weekly basis, not only during 3 rain events. AB 411 requires weekly sampling from April to October at a minimum. Monitoring must occur on at least a weekly basis and more frequently, ideally 5 times per week at beaches with year-round recreational use. Also, since these requirements are addressing stormwater impacts, there's no reason to have a less aggressive monitoring schedule during the winter months. And this year-round monitoring is especially important to me as a surfer because some of the best surf is in the winter, and we need to be able to protect the public in terms of that beach-going use. In addition, flows can be intermittent. So even if flow is not observed during dry weather, previous flow may be impacting receiving waters. Thus, regardless of observed flows, all AB 411 times must be monitored during dry weather on a weekly basis or more frequently. Finally, smaller drains may be impacting water quality, so the model monitoring program should not be limited to just those larger drains. With respect to chemical constituents, monitoring should be increased from 2 storm events for non-point sources to a frequency that depicts variability. We think that nutrients should be added to the list of parameters to be monitored, and that the state board should consider including a basic suite of emerging contaminants, as was discussed earlier today. Regarding benthic community health, in keeping with the current NPDES monitoring program that we see in our region, we urge the state board to have the amendment include annual benthic fauna community monitoring. Also, the state board should include a provision for benthic community monitoring at stormwater outfalls in addition to the non-stormwater point sources currently required. We appreciate that the draft amendments require bioaccumulation monitoring for point sources greater than 10 MGD and phase 1 MS4s once per permit cycle. We suggest that the minimum schedule be once every 3 years. We urge the state board to require bioaccumulation to be monitored through both a mussel watch program and a fish tissue program, as both types of programs for all discharges may tell different things. For instance, mussels may be more indicative of water quality issues in the water column, whereas bioaccumulation tests of some fish species may be more representative of sediment pollution issues. In order to better protect public health, fish monitoring requirements should require whole fish testing because some cultural groups, like numerous Asian cultures, consume the whole fish, not just the fillets. Also, non-point sources should be included in the bioaccumulation monitoring provisions, as agriculture is a dominant land use in some of the coastal areas of the state, such as the Central Coast. Thank you very much for listening to these comments.
Maria, would you like to comment on that enormously long list of changes?
Well, it's only one comment. I think that Sarah probably didn't have enough time to read the last version of the draft SCD, because in page 50, we are talking about the mussel wash sampling. That was one of the that she mentioned. There were some changes, but I think what I heard, yes, she speaks a little fast, so I can say that comment.
But
Some of the things that she already highlighted are already here, taken in consideration.
That was pretty fast, I'll agree. But I do have a couple of comments, if I may. On the bacteria monitoring, I think we did change it to weekly. Yeah. That was a change that we made. And it does say at point 0. So if I understood what Ms. Sikich was saying, I think we did make those changes. As far as the bioaccumulation monitoring, we did keep it at once per permit cycle, whereas I think she was asking us for once every 3 years. We do have mussel watch or a fish tissue program. We give that as an option to the regional boards for bioaccumulation. And for stormwater, we actually included in sort of new technology that's allowable for solid phase microextraction. And that would be the use of a polymer instead of living tissue to collect low concentrations and accumulate them for a laboratory analysis. And that kind of technology has potential uses for CECs. And the allowance for a regional monitoring program would give the regional boards the discretion to include CECs in the bioaccumulation effort. So those are just some thoughts as I was going through or trying to write down some of those comments, just some thoughts there.
did that include the notion, when you say fish tissue, one of the points that piqued my interest is the issue of fillets versus the whole fish, because I know that is an issue in folks that fish for their food and can't abide by the signs that say the amount you're supposed to eat.
The amendments don't specify, they just simply say fish tissue. I know in bioaccumulation work that we've funded through the board and other bioaccumulation studies using fish, it's pretty common to do either whole fish or the portions of the fish, the organs that are high in lipids like the brain and the liver. And so, again, we leave that at the discretion of the regional boards when they devise these programs. They know their areas better than we do at the state level and know what the specific concerns are. And if there's an environmental justice issue, the whole fish might be the appropriate thing, but we leave that up to the regional boards.
Any other questions of staff? I'll move the proposed resolution.
I'll second, and I will point out that when I first joined the board in 2007, is my very first major effort was to go to the first public meeting on this amendment, and we're starting the next one immediately. And so whatever isn't included now goes, I assume, will roll over into the next one. Thank you.
And I just want to be clear, that, once again, sorry, so the record is crystal clear. This motion is only to address the changes that are reflected in the double red underline, double red strikeout in the attachment to the proposed resolution.
Thank you for that clarity. We have a motion and a second. All those in favor? Aye.
Aye.
Any opposed? Thank you. I received notice on my BlackBerry, Mr. Lawfer, that we have successfully drained both Stampede and Boca Reservoir, so we can proceed with item number 12. Thank you.
I'm sorry, I thought there was maybe an introduction. Item 12 is a draft decision conditionally approving applications and petitions in the Truckee River watershed filed by the United States Bureau of Reclamation, Washoe County Water Conservation District, and the Truckee Meadows Water Authority. Following a board workshop on September 17th, 2012, the board issued a revised draft decision on September 25th. The public was given an opportunity to comment on the revised text. Only the applicant and petitioners submitted a written comment letter. We have addressed those issues and made other minor revisions in the change sheet dated October 12, 2012. Staff recommends that the board adopt the draft decision with the changes described in the change sheet and correction of typographical errors. If the board, applicant, or petitioners have any questions about the change sheet, we are available to answer those questions. And there's copies of the change sheet in the back of the room.
Thank you, Jean. Mr. Palmer. Steve Palmer.
I was going to defer to Mr. DePoli, and I may not have any further.
Okay. Gordon, would you come forward, please?
Mr. Chairman, members of the board, Gordon DePoli on behalf of the Truckee Meadows Water Authority. Mr. Piney is also here from the Washoe County Water Conservation District. I noted that Independence Lake is not being drained, so that's good. We would like to thank
I have to do something to amuse myself up here every once in a while, so.
We would like to thank the board and the staff for the attention that it has been given to our prior comments, the comments at the workshop, and the comments that we submitted on the revised draft decision. It appears to us that the change sheet number 1 provides the clarification that we had asked for regarding the Farrah Diversion Dam flow requirement. The other comment that we had was related to the Stampede minimum release condition. And as to that comment, the one thing that was not included was a suggestion that the condition not require at or from Stampede a bypass of water collected to storage in other reservoirs under licenses or permits other than Permit 11605 or the permit related to application 31487. That is not included in change sheet 1, and we have assumed that that's probably because what is left covers that situation. But I might simply state what the concern was there and make sure that that understanding is accurate. The concern there related to, and I think it has to do with how the term bypass is used and how the term release is used. But the concern related to a situation where water might be released from Independence Lake to be transferred to Stampede for essentially the first time to be credit stored in Stampede, and that water would not be subject to the minimum release requirement at Stampede. In at least my mind, that it would not have to be bypassed to meet that, in as much as it was the headed down there for the first time. I'm assuming that really is taken care of in what is now A on the change sheet, and that really is all we have, Mr. Chairman and members of the board.
Aaron, would you clarify from Mr. DiPoli the issue we discussed the other day on bypasses versus releases?
Sure, and in the interest of time, we gave you the very, very short introduction without going into the details of the change sheet. But the reason we didn't include that specific term in petitioner's comments was it's a matter of terminology. They requested a term where bypass collected to storage, and at least under California law, you don't collect bypasses to storage. What we've referred to bypass is letting go of the concurrent inflow. But bypass is appropriate at times in that term because it gives the petitioners flexibility to either bypass or release from storage. But in that one instance where it's specifically referred to bypasses collected to storage, that isn't something that is done, and it's frankly a matter of terminology. So with respect to Mr. DiPoli's concern that the revisions on the change sheet address his concern, I believe that they do.
You concur, sir? I know that was the intention of the language, so.
Yes, thank you.
Mr. Palmer, are you satisfied?
I am, thank you very much.
Thank you very much. This has gone on for a long time. It seems like we've got to drag this out for a while, isn't it? I will move approval as presented.
I will second, and yes, I believe the motion is includes the change sheet
Yes.
number 1 as well. And let me take a moment to thank all the staff who worked on this. I know that you've had a lot of things you've had to juggle, but thank you for hunkering down and working on this very complicated and comprehensive order.
With that,
Really impressive.
what's that, Felicia?
I'm just saying, it's impressive.
All those in favor signify by aye, please.
Aye. Aye.
Any opposed?
And hooray.
Thank you all. Mr. Howard, before Mr. Herrick and Mr. Ruiz's rear ends grow to the chairs they've been sitting in since 9 o'clock this morning, would you please introduce item number 13?
Yes, item number 13, consideration of a proposed order declining to issue a cease and desist order to Mark and Vala Dunkel regarding diversion of water from Middle River and the San Joaquin River. We have Ernie Mona and Mariana Howie presenting.
Good afternoon, Mr. Chairman Hoppen and board members. I am Ernie Mona, member of the Division of Water Rights Hearings Unit, and sitting next to me are Michael Bachman and Mariana Aoi of the Board's Office of Chief Counsel. As Tom said, item 13 is a draft order declining to issue a cease and desist order to Mark and Vala Dunkel. Draft order was released for public comment on September 19th, and 5 comment letters were submitted by the October 4th deadline. And they can be placed into 2 groups. The first group of letters includes comments submitted by the Dunkels, comments jointly submitted by the South Delta Water Agency and the Central Delta Water Agency, and comments jointly submitted by the San Joaquin County and San Joaquin County Flood Control and Water Conservation District. Although this group of parties dispute the State Water Board's authority to issue cease and desist a CDO against the Dunkels, and the State Water Board's authority to regulate riparian or pre-1914 appropriate water rights holders, these parties support the Board's adoption of the draft order with acknowledgement that litigation on these issues is ongoing. The second group of letters includes comments submitted by Valerie Kincaid of law firm of Laughlin in Paris, and comments jointly submitted by the State Water Contractors and the San Luis and Delta Mendota Water Authority. These parties dispute the evidentiary and legal interpretations in the draft order that support the draft order's findings regarding riparian rights, and they do not support the Board's adoption of the draft order. Furthermore, the State Water Contractors and the San Luis and Delta Mendota Water Authority request that the Board defer issuance of an order until after the reopened hearing on the Wood CDO matter is held. As you recall, the Board issued Water Right Order 2011-005, and that was followed by a second order 2012-0012 granting reconsideration of that order, and part of that reconsideration was the reopening of the Woods hearing to allow Woods customers to come in and present legal argument and evidence to support their claims of right for the use of water diverted by Woods from the Middle River. It's my understanding that that process will be delayed per agreement by the parties to that certain litigation until the final litigation regarding the Board's authority is resolved in the appellate court and so on. After review of the comments, staff recommend that the Board adopt the draft order with the changes described by the change sheet that was circulated on October 10th. Change sheet shows basically 3 changes. The first change is simply to address the first group's request that we add some additional language to the order to recognize the fact that the previous orders that we referred to in the draft order regarding Woods or the Board's authority is being litigated at the time. And the other 2 changes are simply just consistency changes so that the order is looks good. And thank you very much. That's all I have to say.
I hope those who comment on this will comment on whether or not the order looks good.
Mr. Herrick, sorry to make you wait so long. I know a day here is very entertaining, but
yes, it's very, very nice to sit here all day. But that's
I want to know what you think about the use of
popcorn.
That's right. I just want to know what you think about the use of the word soul.
I've never liked fish. Thank you, Mr. Chairman, board members. My name is John Herrick, today representing Mark and Vala Dunkel. As staff said, we think the order is appropriate and we support adoption of the order. I appreciate the addition of I think there's a reference and a footnote regarding the authority issue being decided in the courts now. Without wasting your time, I'd like to give a brief history of how we got here, and that is, I think about 5 years ago, there was a report produced which concluded that on the face of an examination of lands abutting waterways and licenses on file with the State Board, that most of the South Delta was full of illegal diverters. So based on that document, the California legislature saw fit to accuse us of the same thing, adopt laws to require the investigation of us, and even require the hiring of a person with the sole purpose of investigating South Delta or in-Delta diverters. The State Board took the allegation hook, line, and sinker themselves and adopted a strategic plan which made one of its priorities the investigation of South Delta diverters. And so 4 years later now, I think we can all agree that we've wasted hundreds of thousands of dollars, and we've come up pretty much short of any substantive or beneficial result. Mark and Vala Dunkel own 40 acres of land in the South Delta. 40 acres of land, by general calculations, would use about 1/2 CFS during some months. And to pursue that as a means of addressing California's water problems would seem like an ill-advised errand. Once the Dunkels presented evidence that they were receiving water pursuant to Woods Irrigation Company, which was formed in 1909, this matter should have ended because they made a showing of a legal method of getting water on their property. Regardless, we went through a hearing, and we now stand here before you. As the order mentions, the land, the Dunkels' land, was part of a larger parcel that was connected to Middle River. That's not in dispute. And then after, or while it was still connected to Middle River, hadn't been separated from it, agreements from the Woods Company were entered into which provided a means by which the owners of that land could get water from the river, or maintain a method of getting water from the river. So we have a 100-year-old process where people who were unarguably riparian preserved a method by which they could still get water, and thus an intent to preserve their water right. To conclude that somebody intended to not maintain a water right after they preserved the method to get water would be counterintuitive, and we submit wrong. However, we're still here, and you will hear shortly from other parties that these people should not be able to divert, there's no riparian right, there's no history of use, and that they should be sanctioned and prevented from using their land. I just want to say I think that's an unsupportable position. We've gone through this before in the Term 91 hearings, and I don't think anybody was here then, whereas this board made the same conclusion to this person's neighbor, that being riparian to the Middle River, before it was separated, they entered into an agreement with the Woods Irrigation Company to maintain a method of diversion or a method of delivery of water, and that person was held to be fine, had preserved a right. So I would encourage the board to adopt this order, and we can move on and get into the really meaty things that are coming up in the next year. Thank you very much.
Mr. Herrick, there's things in my life that I miss. Mr. Hildebrand's one of them, Paul Harvey's another one, and Paul had a saying about the rest of the story. I think there's one thing that, and I don't disagree with a lot of the chronology that you went through, but had the Dunkels submitted the basis for their belief of a water right when they were initially asked, this probably would have taken the course you identified as being the most judicious way to handle it. So I would like to include, on defense of my staff, that had that response been made that provided their opinion and their valid proof, that it wouldn't have taken quite so long.
That is potentially likely, and I would say that since that time, I believe I've had a very good working relationship with your staff, and we've addressed, and to our mutual satisfaction, not other parties, have resolved numerous other issues in the South Delta. Thank you very much.
Thank you, sir. Mr. Ruiz.
Good afternoon. Just real briefly, Dean Reese on behalf of Central and South Delta Water Agencies. Chairman, your staff was kind enough to put in its notice that items 12 through 15 would not be heard till after 1 p.m., but unfortunately I wasn't smart enough to read that until 11 a.m., so that's why we've been sitting here all day long. But
you know, I felt guilty because I could tell that that was happening, but we had people that were making their impassioned pitches, and I knew you and Herrick were sitting ducks over there, and not, you know, you could have at least had a good lunch, so I tried to get it in as quickly as I could. I did not do that intentionally just to make you have to labor through this whole thing.
Our own fault for certain. But briefly, the agencies participated in the Dunkel hearing in support of the Dunkels. We submitted a comment letter urging adoption of the draft CDO, in that it declines to issue a CDO against the Dunkels. And I just simply reiterate and state that the agencies find it a matter such as this, even though it only involves 0.5 CFS, to be of paramount importance to our mission, and we urge you to adopt it. you've already fully stated and well understand that we continue to take issue with the authority issue, but that is up on appeal, and that's been discussed ad nauseum here, and I won't repeat those arguments again.
Thank you.
Thank you.
Valerie Kincaid.
Good afternoon, Chair Hoppen, board members. Valerie Kincaid, appearing before you this afternoon on behalf of Modesto Irrigation District. MID does not support the proposed order as drafted, declining to issue a CDO, as Mr. Mona indicated. And our written comments go into the legal reasons, the 1911 agreements that Mr. Herrick touched on, and I won't reiterate those points here. I do want to make a more macro policy comment before you today, which is that given the atmosphere of regulation of existing legal water users, the MID would certainly encourage the board to take a harder line against curtailing unlawful water use. And we do not view the proposed order as consistent with that hard line. We think it gives the Dunkels a hall pass, as Mr. Hoppen mentioned. Evidence was not put forth initially, and MID believes was never put forth in the hearing. And because the order does not strictly interpret the laws that the State Water Board is supposed to uphold against water users, we oppose and don't think the board should adopt the order declining a CDO today. So thanks.
Thank you, Valerie. Mr. Rubin.
Good afternoon, Chair Hoppen, members of the board. My name is John Rubin, and I represent the San Luis and Delta Mendota Water Authority. The San Luis Delta Mendota Water Authority does not support adoption of the order. I will just incorporate our prior comments, both in terms of comments made during the proceedings as well as on the draft order. Do not believe the comments have been addressed by your staff and are or adequately addressed in the draft order that's before you today. I want to make one additional point that was reflected in comments submitted by Ms. Kincaid on behalf of MID. In her written comments, she highlighted an issue that, again, is still not addressed. It relates to our principal concern, which is regarding the evidence that's before you. In our prior comments to you, we've taken the position we still believe that the evidence is insufficient to support the findings and conclusions that are being made in the draft order, or that should be made in the draft order. But Ms. Kincaid points out an additional point that was not before you at the time of the hearing, and that is the order 2011-0005. In a written comment, she noted the inherent inconsistency in findings and conclusions in order 2011-005 and the draft order that's before you. We believe that that is an additional fatal flaw in the draft order that's before you, a failure to address, reconcile the two orders. And for that additional reason, we believe if you adopt the order today, you'll be committing a legal error. Unless there's questions, that concludes my comments.
Thank you, John. Any questions of staff?
I just would like staff to respond to Mr. Rubin's last comment.
Certainly. Let me just refresh my memory by reviewing Ms. Kincaid's letter for a moment, and then I will explain the reasoning of why, or to what extent we responded to the comment, or if we did not, why.
Any other questions while Mariana's reflecting on that?
If it's of assistance, this is John Rubin again for San Luis Delta Mendota Water Authority. They're specifically in order 2011-005. On page 30, there's a discussion about evidence regarding the development of a pre-1914 water right, and in that discussion, there's analysis of pre-14 rights that rely upon, in part, the 1911 agreement that's also addressed in the draft order before you.
Thank you, John. So I did actually go back and review the Woods order after reading Ms. Kincaid's letter, and in several, I feel the Woods order addresses actually the point that they're bringing up. They allege that the fact that the Woods Irrigation Company is claiming a pre-1914 water right based in part on these 1911 agreements, and that the Woods order acknowledges that that might be possible to a certain extent. We say it has not, it hasn't been proven otherwise up to the 77.7 CFS. Let me know if I'm losing anybody. I know everybody wasn't here for the Woods matter. Minus whatever riparian rights might be in the parcel that the Dunkels are in. The Woods order does go extensively into the relationship between the riparian rights that it finds are maintained on parcel 2, and says that it's possible to develop a pre-1914 right either in Woods or by the shareholders themselves without making a decision as to who actually has the right, based on the fact that if it's Woods' right, they could have diverted it themselves. If Woods is serving as an irrigation company, for the shareholders of the company to serve their own individual rights, that was also possible for them to do. Either way would not have been a violation of the law. So we didn't actually make a finding as to who held the rights, but we did find that it was possible that the same instrument could both maintain a riparian right to lands in the larger parcel that that existed whole at the time that the 1911 agreements were entered into, and could serve as the basis to form a pre-1914 appropriative right. Did I lose everybody? Okay.
Let me try casting it a slightly different way, and Ms. Owie can correct me if I'm oversimplifying it. Essentially, the findings between the two orders and what they're based upon is not incompatible, but instead there was no definitive determination in the Woods order as to the nature and extent of the right. But that doesn't change the fact that the 1911 settlement agreement could be used in either context to support the particular right at issue. And in this board's order, it's the finding that there's sufficient riparian right preserved to authorize this diversion.
If it's helpful, I also pulled out a few quotes from the Woods order that address this issue, if you would like for me to read them.
And if I may, sorry, to just clarify, I don't want to get into the back and forth and have a cross-examination situation here, but the comments I made were somewhat to the effect of what Mr. Lawfer just explained, but perhaps the inverse. It's my opinion that you cannot have a document that both evidences a pre-14 water right, and also the same diversion would also evidence a preservation of intent to an intent to preserve a riparian right, thus creating two different water rights, one appropriative, one riparian, from a single diversion. And that's what's going on here. That's the crux of the problem. We're using one document to create one diversion to create two rights. It's a big problem. It's unlawful, and the staff, in my opinion, hasn't addressed it. So,
Ms. Kincaid added a little bit more to her comment. Would one of you like to address this water right as far as having a dual purpose, if you will?
Frankly, I think we'll probably just have to disagree, and I believe that it's been adequately explained, both the nature of the finding in the original order and the reliance upon the 1911 agreement, both in this order and in the Woods order.
Thank you, Ms. Lawfer.
I move we adopt the order with the change sheet.
I second.
All those in favor? Aye.
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 Any opposed? Thank you.
Aye.
Mr. Howard, we've been waiting all day for the executive director's report or the highlights there.
Actually, I wanted to provide just a brief post-mortem of the last item. Mr. Herrick provided a brief history and assessment of the value of the Water Board's work regarding looking at delta diversions and the question of whether they were lawful diversions in the delta or unlawful diversions. This issue, we tried to, in 2008, the Water Board tried to develop a comprehensive work plan identifying all the activities that needed to be done in the delta. And one thing that we felt it was necessary to address was the fact that there were widespread allegations of unlawful diversions in the delta. Many people were making these allegations, and since the Water Board was claiming that it was going to do a comprehensive approach, it felt that it was necessary to try to address that issue. We didn't exactly fall hook, line, and sinker into those allegations, but we felt they warranted investigation, if for no other reason than to put to rest those allegations. And so we redirected 6 people to investigate the water rights in 2 islands. We have, essentially completed our investigations in those 2 islands. The conclusion I would draw personally is that if we look hard enough and long enough, we can find occasionally someone who has questionable water rights, but that's a condition that exists throughout the state of California. And so I think that we can draw the conclusion that all of those allegations were inaccurate, and I think that was an important thing for the Water Board to be able to assess and answer in light of all of the important issues associated with the delta that are ongoing.
Tom, would it be fair to say that, and maybe it just coincided with my initial time on the board, but at that time all of this was being precipitated, or these accusations were being precipitated by the outcome of the Phelps case, which certainly identified some illegal users of water, and it was portrayed to us certainly that everyone down there was doing exactly the same and we needed to pursue them. Is that?
I think the Phelps case was certainly a factor in the issue. Of course, the Phelps case was specific to Term 91, and there aren't that many delta diversions that have Term 91 in them in the first place. But certainly it helped to fuel the issue. And with that, yeah, I have no further comment on the Executive Director's report. There's nothing startling in it, I believe, but if you have any questions, I'd be happy to answer them.
Not seeing any.
Thank
Mr.
you.
Lawfer, can we adjourn, or would you like to go into closed session?
No, we'll go ahead and adjourn.
Okay. We will stand. That's what I get to tell him now. We'll stand adjourned. Thank you. Ms. Evoy, I was tempted a couple times to see if it would really go 15 feet, but I wasn't sure the dais really went that far.